we also now want to deal with the issue of credibility, along with these other ones, to say the disposition of Inspector Rapiri, particularly him, was someone who was hell-bent on sticking to the Crown's narrative at all costs. Very unreasonable. And will demonstrate how, Your Worship. Inspector Rapiri was asked in the witness box, when did Rapiri o he ho lokolla ntate Lipholo ho tla tshwana le ho lokolla Mbidithamai ya paleo? Inspector Rapiri said yes. A tshova le ntate Rapiri a o lokolla ntate Lipholo tshwara hantle la o lokolle tseng ya paleo polesala msomtlotle. Those are the lengths to which he was particularly willing to go to stick to his narrative. That unreasonable attitude should be taken into account by the court in rejecting entirely that testimony in this matter. Yes. And then lastly, I would say again, the testimony of Mbidithamai dealt with substantively everything that he said. All the allegations. May you say, all those were then rebutted by the mother of Mbidi. And to that we'll say, we submit that the court should accept the version of the mother. But we think the mother would know better than you, better than them, as to blood relations. We submit. So, on the evidence, I was surprised that Malan and colleagues say they've proven relations beyond a reasonable doubt. While we share common cause on other issues, we are diametrically opposed on that one. We are diametrically opposed. The evidence, there is absolutely no evidence whatsoever, Your Worship. No evidence whatsoever of any relationship. Any relationship whatsoever. And in the absence of that, in the absence of any factual basis, what we are left with, which is common cause, by the way, is the fact that, oh well, the surname of the magistrate is Tamai. Oh well, the suspect who we are still searching for also is Tamai. That's what we are left with. Oh well, the magistrate also stays somewhere in Mazinoto. And this Mbidithamai stays somewhere in Mazinoto in a different village. And therefore, also have Tabakwena. Which I am one, by the way, totally unrelated. I was even afraid of getting when I go to the You worship, amen. And I think we should give Inspector Bukupane credit because understand he said, he was fair now. He admitted under cross-examination, Mr. Bukupane, that these factors could never be held by a reasonable man to be a reasonable apprehension of harm, and we submit he was correct. And I'm glad my learned colleagues also did not even raise, they did not really insist on those. But they are not determinative. And lastly, our submission is this, Your Worship, and this is now covered even by the authorities that we have submitted in our written submissions. That an application for recusal, it's a very sensitive application because it hits at the very heart of the integrity of the judiciary. It hits at the very heart of the judiciary itself. And it is something that should never be taken lightly at all. At all. It is done in the background, Your Worship, of judges and magistrates who have taken oath, as Your Worship has done, to administer justice without fear or favor. And that oath presents a presumption on the part of judicial officers that indeed in the conduct of their work, they are bound by that oath. And that presumption must be rebutted. It must be. It's a legal presumption of law that because of the oath that judicial officers take, they are presumed to be fair. And that presumption cannot be, it can't displace that. You need more than that. You need more than that. And such is the high bar, Your Worship, such is the high bar for recusal applications that a magistrate or a judge shall not entertain it or shall never succumb to it unless there are reasonable grounds upon which it's made. And we submit that in this case, the only reason for the application for recusal was so that we could postpone the application for release and therefore should be dismissed. Because we must, Your Worship, and lastly, I just want to say, it should not be lost that the accused person before court today is in a position where he's saying, I have been stripped of some of my most fundamental rights. The right to freedom. That is what is central to this application. And an application of that nature is inherently urgent because he seeks to vindicate and the conduct of the prosecution in this matter, the Crown. The less said about the investigating officers, the better. Has seriously hurt the interests of the accused. So it must necessarily be urgent. Now, for the Crown to postpone it, it's unfair, Your Worship.
Are you addressing the court on the issue of the postponement, or you're still on the recusal?
No. We are on recusal because we're saying this recusal is actually tantamount to a postponement because it has had the effect that the prosecution or the Crown has always wanted. That is what it has achieved. Yes, it has achieved that which they could not obtain through addressing the court, which is to postpone the main application. They found it through mechanisms of a recusal application, which should be seen as nothing but a stratagem to further postpone the matter. We submit, Your Worship, as the court places. Your Worship, my colleague, I beg your pardon, has raised an issue that there's an issue that was made by my learned colleagues raised an issue of what transpired in chambers. Our attitude towards that is that, one, the Crown was given an opportunity to bring witnesses. To provide the basis, the factual basis for their application for recusal. Evidence was led and closed by the prosecution. They actually even had 3 witnesses. We even asked, you want more? So that none of whatever happened in chambers or anywhere else came from the witness box. And we cannot have evidence being thrown in through heads of argument. But first step. If anyone wants to give evidence, should go to the witness box, be subjected to cross-examination. Apart from that, I was about to say I don't have any recollection, but I will not give evidence from the bar, Your Worship, we submit.